Thank you, Your Honor, and good morning. We're here on a state grand jury case, State versus Cory Fleming. Mr. Fleming was indicted in March of 22 for 2021 GS 4730, as well as in April 2022 for 2022 GS 4702. Ultimately, these state grand jury indictments were 23 counts and included 2 counts of money laundering, 10,000 or more, 7 counts of breach of trust, 10,000 or more, 5 counts of breach of trust, 2 to 10K, 2 counts of insurance fraud, 2 counts of criminal conspiracy, 1 count of computer crime, 3 more counts of money laundering, $300 to 20K, and 1 count of breach of trust, 2K or less. He ultimately pled straight up to those offenses before the Honorable Clifton Newman back on September 14th, 2023. The matter of restitution was deferred, Your Honor, and as Your Honor is aware, you've been assigned this matter, and that's what we're here today to address, is that matter of restitution for those offenses. I think the first matter that we do need to address is my understanding, of course, Ms. Barbier is here representing Mr. Fleming, and I do believe that he has waived his presence, so I think we need to address that matter, and then I'll be happy to go forward with what's on the table, Your Honor.
Ms. Barbier?
Yes, Your Honor. Good morning. May it please the Court. Mr. Fleming and I have discussed his right to be present for this proceeding. He has told me unequivocally he waives his right to attend this hearing today, and so we are prepared to proceed without him here.
Very good.
Thank you.
Probably for the record, we should note as well that Mr. Fleming filed a timely appeal of his, plea and sentence, or sentences rather, and the Court of Appeals remanded this case back to us for a final determination of restitution before proceeding with the appeal. So that's why we're here, even though he had appealed.
That's correct, Your Honor.
Judge Newman's sentences.
Yes, sir, Your Honor.
Happy to hear about it, Mr.
Thank you, Judge. Ultimately, in accounting for restitution, the offenses, 23 of them, fundamentally revolved around 2 things, and one of them had to do with the Satterfield matter, and one of them had to do with the Pinkney matter. And Your Honor, of course, he also pled guilty in federal court, and a restitution order was issued there that only addressed the Pinkney matter. As Your Honor is aware, though, that we have independent state obligations here, independent state obligation for restitution, and of course these were state court actions and abuse of state court licenses, law licenses that ultimately led to the conduct at issue. And so there needs to be, the state would submit a state obligation that goes along with those. However, as Your Honor is also aware, there are particularly statutory offsets, and generally restitution is not there to give a windfall to someone. So we've had the very complicated task of going through each element of these various amounts and determining what other recoveries there have been. And that of course, has been the challenge that the parties have been working on and have had discussions with the court. One thing I do want to note is that under 1725-324A, that, of course, provides that secondary payees or third-party payees, secondary victims, can receive restitution, but it does exclude an offender's insurer from that. So that's one thing that we've had to address as well. Ultimately, I'll start with the Saterfield matter, and we have kind of gone through and broken down the various amounts as well as the various known recoveries as we look at that in the context of state restitution. And again, it's important to note that criminal restitution is not meant to be not meant to account for all the possible liability that someone may have. That there could be civil liability, there could be different civil causes of action, there could be others that are civilly liable for their role in a particular instance. Criminal restitution focuses on the particular culpability and the net loss of the victim and the defendant here. If we look at the Satterfield case, we had ultimately 4 main figures that were dispersed, and the first one was $403,500. This was the first amount that Cory Fleming diverted through his scheme with Murdaugh, that Alec then ultimately converted through use of the fake forge account. The second amount was $2,961,931.95. That was the second disbursement that Cory diverted to Alec, who then converted it through the fake forge account. There was a $118,000 disbursement, again, that Cory diverted to Alec, that then was converted through the fake forge account. And then there was $113,800 that was remaining in the trust account when all of this kind of came to light, and that was dispersed to the Saterfield estate by Mawson Coon. Your Honor, those total $3,597,231.95. On top of that, we have 3 individual checks that were just stolen by Cory Fleming that had nothing to do with Alec or anything else, and that was an $8,000 check, an $8,500 check, and a $9,700 check, and that total is $26,200. Ultimately, that totals $3,623,431.95. And then when you add in the actual expenses and everything, that comes up to your total recovery. So what we've had to do is then account for the various offsets that are out there. And the first one was that there was $3,875,000 that was paid by the PMPED malpractice insurer, to our understanding. They, of course, are excluded as a third-party payee pursuant to the statute that I just mentioned. So that takes care of that one. Ultimately, there was $25,000 that was paid by the law firm as a deductible, but ultimately, in communications with the counsel for the law firm, while they do not waive restitution, they believe the amounts in the federal order are sufficient, and therefore, and they understand that that does not include that deductible for the Satterfield matter. So that takes care of that one. Moving on, we had $450,000 to our understanding that was paid by the Mawson Coon malpractice insurer. Again, that's excluded pursuant to the statute as a secondary victim or third-party payee. And then we had the $5,000 deductible that was paid by Mawson Coon. However, in conversations with Fred Coon, they have waived seeking any restitution as a secondary victim from Mr. Fleming. On top of that, we had, once everything sort of came to light, ultimately Mawson Coon refunded to the Satterfields a total amount of, I believe it was about $676,255.59. And the components of that were the $650,000 fee that Cory Fleming had taken as part of his role in this scheme to defraud the Satterfields. There were also included the $26,200 in checks. And when we did our math and double-checked it last night, that amount was included. Those 3 checks that Cory stole was included in that. And then finally, there was, I think, about $55.59 in actual real expenses. And so that is what led to that total amount. But in any event, that was paid back by Mawson Coon, and again, in conversations with Fred Coon, that he's confirmed me by email that they waive seeking their rights as a secondary victim for the amounts they had to pay back on behalf of Mr. Fleming for his misconduct while a member of that firm. So ultimately, that sort of walks through the very large amounts that we have to deal with on the Satterfield side, and so just component by component. And so again, I'll move on now to the Pinkneys. But just to go ahead, as we've discussed, that ultimately, so that we've analyzed every bit of this, I think after this hearing, assuming that we're all on the same table or on the same page, I will draft a proposed order that sort of does this analysis so that we can walk through how that was done. Moving on to the Pinkneys, ultimately there were 2 checks that were stolen by Cory. The first one, Cory Fleming, the first one was $6,490. And the second one was $1,588.46, and these were the 2 checks that Mr. Fleming billed as a medical expense to Ms. Pinkney's account, but instead were used to pay for him and Alec to fly to the College World Series in a private plane. There was also a third check for $4,560 that Mr. Fleming improperly diverted to Alec for supposed expenses that were not real. And then finally, we had $89,133.44, and that was the amount that Mr. Fleming diverted from his trust account to the law firm's trust account that then were converted by Alec through the use of fake forge. And so those are the components of the amounts that are restitutionary solely as it relates to Mr. Fleming for Ms. Pinkney. As I mentioned before, there was a federal restitution order entered, and it has both the $89,133.44. It also has the 3 checks. The feds had a math error in there. They had it for $13,088.46. The actual amount is $12,638.46. Again, that was an error, but it inured to the benefit of Ms. Pinkney. But ultimately, I think that we have to remember is that, again, there was state liability here. There were state convictions for this abuse of state law licenses and state court actions before state court judges. And there needs to be therefore that state accountability. And so ultimately what the state is seeking and proposes is having that concurrent state obligation for those two restitutionary amounts as it exists for Ms. Pinkney. The first being the $89,133.44, and the second being the $12,638.46. I want to be clear, of course, that the state is not seeking double recovery because that obviously the law doesn't support that. But it is important to have that concurrent resolution, and in any proposed order with the court's permission that I would prepare would, I think, make it very clear that any amounts paid to either entity would be credited against the other, and that ultimately we not only have the recognition of that state obligation, of that state restitutionary obligation, but we also have that backstop as well, that in the event something happens to one conviction or the other, we've already seen Russell Lafitte's conviction get flipped, there is that still that state obligation remaining to ensure that that restitutionary obligation remains. And so ultimately, my proposal to the court would be to draft a proposed order that does, in a little bit more detail, but does the analysis that I just walked through with your honor. Obviously, submit that to defense counsel for review, and then ultimately, if we have that be the court's order as it relates to restitution.
Ms. Barbier.
Yes, Your Honor. I'll start with the premise that restitution, as we know, is an equitable remedy. And the ultimate goal of restitution is to promote fairness and justice and to make a victim whole. And I think the state concedes in this matter that the Saterfields have been made whole. The amount of restitution that he just mentioned in his analysis, the $3.6 million, has been more than returned to the Satterfields through settlements totaling what I understand to be $9.3 million. So thankfully, the Satterfields have been made whole with respect to that, the wrongs committed against them. With respect to the Pinkneys, there is an existing federal court order of restitution in the amount of $102,221.90, which Mr. Waters just indicated is a little bit more than the Pinkneys were actually entitled to, approximately, I think, $800. So that was in their favor. A federal restitution order, as we know, is good for 20 years. It is a judgment after this period of supervised release and payments are made to the extent possible by a defendant. A judgment then is entered which is good for 20 years. So we believe that the matter of restitution has been sufficiently taken care of in this case. We are not opposed to an order that would indicate that there is an obligation to pay state restitution should the federal restitution not be satisfied. I know that the time periods for Mr. Fleming to appeal his federal restitution order have lapsed. He cannot take that issue up in a 2255, and unless his conviction were somehow vacated in federal court, that restitution order will be sound and valid for 20 years. So I believe that everybody's interests here are taken care of. I will review the proposed order that Mr. Waters drafts and, obviously submit any objections to it and do that in a timely manner as the court directs. Okay. Thank you.
All right. Mr. Waters, how long do you think you need to get me an order?
Your Honor, we could get through Christmas, maybe on the other side of Christmas. I'll get you something because I think we all want to get this done behind us. But
we need to get it back up to the Court of Appeals.
Yes, sir.
And I want to be explicit in the order that this is concurrent, as we discussed, and not in addition to.
Yes, sir.
I know Ms. Barbier had some concerns that there may be some confusion down the road as to this being some additional obligation. I think our statutes are pretty clear, and the relatively little case law that it's not to be any sort of double recovery, and he's entitled to any offset on this that he's paid through other areas.
Yeah, absolutely. I'll make that excuse me, Your Honor, I will make that clear again. I couldn't in good conscience seek a double recovery. And I do, as the court knows, I do need to point out, we talk about victims being made whole. I am always reluctant to use that phrase because, again, a victim may have various civil causes of action and that sort of thing, that the criminal restitution process doesn't exist. In the end here, Mr. Fleming is very, very lucky because he had insurance essentially that paid for his criminal actions, and the statute precludes him having to reimburse that insurance for that. So that's what the law says, and that's what we're having to deal with. And so we'll obviously make that very clear in the order.
Okay, and make it clear too in the order about the secondary or third party payees that have waived their right to restitution as well. Because I think didn't PNPD waive another deductible or something?
Yeah, I'm always careful about wavering, and I've been in this situation before. They believe that the federal restitution is sufficient, understanding that the Saterfield deductible is not included in that, but they were very clear they don't waive anything. Now, Moss and Kuhn through Fred Clune did waive. And again, I don't mean to dance on the head of the pin, but I've been stung by this before to be very careful about how I represent a victim's positions when there's all this civil litigation and all these things that are out there.
Or maybe just somehow include that they have agreed to accept through their counsel, Mr. May, the $89,000 figure, which would not include that 25 or 26.
I'll make that explicit.
Okay.
Yes, sir.
Anything else?
Your Honor, just to make sure this is on the record as well, my primary concern in objecting to this initially was that I did not want there to be dual payments that needed to be made when Mr. Fleming is released from incarceration, a state restitution payment in addition to a federal restitution payment. As we all know, it is very difficult when someone gets released from prison to make any payments on restitution because their employability is somewhat compromised. So I just want to make sure that the order addresses that as well, that will not be a dual obligation by Mr. Fleming.
Okay.
Thank you.
All right, we'll make sure we get all that done.
Yes, sir, Your Honor.
Anything else?
Nothing from the state, Your Honor.
All right, thank you all for coming.
Thank you, Your
Judge.
Honor.
Give me an order at the first of the year, we'll take care of it.
Yes, sir.